Good day, everybody. This is Sam Shihab with Sam Shihab & Associates. Today is our day to spend 1 hour together to go over substantive issues in employment immigration law and answer your questions. My dear colleague Brian Burke is on vacation this week, and every once in a while he's allowed to go on vacation. However, before he went on vacation, we recorded a session that we would like to share with you. Stay with us. So I guess, Brian, we have two important topics.
Yes, sir.
The ombudsman interview.
Yeah, their sort of presentation, their seminar on
Presentation, yes.
how they're addressing employment-based green card applications, very relevant to our audience.
There's some nuggets of very important information that we have picked up that we would like to share with our clients and audience and friends. And then we're going to dive into INA 245K, which is really one of the very few commonsensical law that can save the green card if there is a misstep in immigration violation or status violation or work without authorization or any other problem.
Yeah, it's really useful for employment-based green card applicants that can really kind of save their butts.
Yes, it basically, it comes from the fact that we're all humans and we make minor mistakes, and some mistakes will be forgiven under certain circumstances. So let's dive in the ombudsman presentation that happened last week.
Yeah, May 26th.
And let's see what we've learned from it.
So USCIS has this, sort of presentation about how they're doing on employment-based green cards, which is a very hot topic because there's a ton of them available this year. So basically, they sort of went through and sort of explained, how they're doing, the challenges they faced, and gave some very interesting insights as to sort of how they think they're going to be doing, how many of these green cards they're going to actually be able to issue this year. So let's talk about, about the sort of little violin playing they're doing for themselves, talking about their problems. They talked about really all of COVID. They talked about, staff being unable to work during the times of COVID. When COVID really hit initially, Sam, immigration applications were way down from that period of March 2020 to September 2020. And that basically caused a funding crunch for USCIS because there were just less checks for cases coming inside the door.
No rain day funds. With all the money that they receive every year, they don't have any system of rain day funds. Every organization has a emergency funds. They don't have. I mean, there's nobody with a finance degree, I guess, in the organization to have some funds.
I guess, Sam, when you're the government, you print the money. You don't have to have a rainy day fund, right?
Not really. I mean, obviously, they were down and their employees stopped working, and they're saying, "Oh, we ran out of money."
So then, we're dire straits. We can't do anything. There's no cases coming in.
Yeah.
Then October 2020 hits. Tons of cases come in the door. Thousands and thousands and thousands of green card applications, and they didn't have their staff there. And January 1st, 2020, January 2021, people start coming back to the office, and they go, "Oh my God, we have this massive backlog of cases."
And
here.
They mentioned 1 million cases.
Yeah, it took them up to July to catch up on actually receiving all of these adjustment of status cases. Crazy.
So just an observation. So finally in January 2021, so they were absent, doing nothing for a long time.
For the last quarter of that year, from October to December.
Yeah, and then they came back and they're saying we got 1 million cases in our office that we have to handle. Yes.
Yeah. So really, it seems like they were just sort of buried until about halfway through 2021 and just processing the cases that came in. And I guess that kind of reigns true because there were lots of people, there are people out there who still haven't gotten their fall 2020 EADs. I imagine there's a few of those left, but it took a lot of time for people to get any sort of notice, any sort of update about these cases. So
What about the I-693 comment?
Yeah, and
that's an upsetting one.
We were talking about this. This was kind of irritating to us. So I-693, USCIS said, well, one of the challenges we hit is that cases didn't have I-693, the medical examination, right? That's per their own policy. It says very clearly in the I-45 instructions that you're not required to submit the medical exams at the time of filing. Submit them in an interview or submit them later, whatever you want.
Yeah.
You know, so to throw that back at us.
So they're using that as an excuse for not being able to approve
Yeah.
cases.
But ever happy to pat themselves in the back. You know, USCIS talked about the good things they're doing, and I understand. You know, I'm being a little bit sarcastic, but they are trying. So they ended their hiring freeze. They're redistributing workloads. We know they've been doing this. They've been shifting their employment-based green cards from the Texas and Nebraska service centers to the National Benefit Center and ultimately local field offices where they have, you know, people who can handle things. To correct their I-693 problem, they're sending out, you know, late last year, those notices saying, hey, if you didn't send us your medical exam, please do so.
So just a pause. If you have not sent your medical exam, send it now.
Yeah.
Because obviously they're saying, well, it slowed us down a little bit. So I think probably everybody has done it already.
Yeah.
But if you haven't done it, just send your medicals right now.
They're doing more hiring. Right? And they expect to have people onboarded. All those people, most of those people, I think, was 90% on board by the end of this year.
And they encourage interfiling.
Yeah, to keep their workloads down. Basically, we will approve your case based upon that transfer underlying basis, rather than taking a second case, which will bog us down even more.
And they gave us some numbers finally.
Yes. So USCIS says at the end of the last fiscal year, they wasted 66,000 visas. And we knew that. We talked about that number before. And that's upsetting because that's 66,000 people who didn't get a green card who could have gotten
moved on.
Yeah, and those visas are toast under the way the law works. They are unretainable. So then they say for fiscal year 2022, they had 281,430 employment-based visas available.
This year.
Yeah, and that's a really, really concrete number. And, you know, we had seen estimates of a little bit higher before. So that's a really good concrete number. And as I recall, Sam, we saw in Q1 USCIS processing statistics, they had about 284,000 employment-based adjustments in their hands. So more than that, more than enough to fill up all those visa slots.
Right, but not necessarily in the right category.
Not necessarily. That's
So
obviously
that's
one of
why they're asking us to transfer the underlying bases because they are in the AB3, they want it in the AB2 to be able to process it. But go ahead, Brian.
Yeah. So then they started talking about, you know, how they've done. They say that in a typical year, they grant about 115,000 visas. Okay. And last year, they completed about 50% more than normal. So that's around 175,000, right? And they say they are on pace to approve even more this year.
But they're just not telling you, but they're confirming that they are going to waste a green card, clearly.
Well,
I mean, this is an absolute confirmation for the first time from the government this year that they have confirmed that they have every intention to waste some green cards.
I don't know if
Yes or no?
No. So
Why?
My answer is probably. So there's 81,430, right? And there's 175K where they say we're gonna beat that, right? So they're happy with themselves if they beat last year's number. They issue 180,000, right? I do fully admit that they can beat themselves last year and still have a massive, massive, massive difference between the visas available and they issue, and there's a very large potential to waste a large amount. I wouldn't say they've guaranteed it. In fact, I agree with you. You predicted months ago, Sam, extrapolating that they're going to waste more this year.
We projected 80,000.
Yeah, I think it was 80,000. It was based upon the fact that if they wasted 60,000 last year and they're going to keep on the same pace probably, they're going to probably waste, you know, more because there's more visas available this year.
Yes.
So, okay, it looks like it, but they haven't so much confirmed it in my book. They're just saying we're going to beat last year, and I guess what I'm saying is they have to really, 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 really beat last year if they're going to use up these visas.
So
I'm a lawyer, Sam. I'm supposed to mince words.
No, but you and I are on agreement here. First of all, what's wrong with this picture? I'm going to share with you the way I look at it. What's wrong with this picture? Number one, the premise is wrong. That they are required to approve 115,000 every year. The premise is wrong. They're required to approve all available green cards.
Yeah.
And the law hasn't changed in 20 years.
Yeah, you're saying they're content to their standard is reaching. We're going to beat last year where we approved about 175,000, and that's their metric. That shouldn't be their metric. Their metric should be to approve 281,000. Right?
That's not the problem I have.
No?
No. The problem I have is the statement that we approved 50% more than we should have. Hey, high five. No.
Okay.
No, they didn't approve 50% than they should have. They should have approved 260,000, remember?
Yeah, they should.
That's the number, right?
Yeah,
last year?
Yeah, something like that, yeah.
Okay. They failed, okay, on the account of 66,000 green cards last year. They did not approve more than 50% than they should have.
They
which
approved
is
less than 100% of what they should have.
Yeah, the error in the logic in the presentation is that on a normal year we approve 115,000, we approved 175,000, so we approve 50% more, and we're going to do better. No. On a normal year you should approve all the available visas. Last year the available visas is 260,000. You approved 175,000. You failed by approximately 66,000 green cards, and you're going to repeat the failure one more time this year.
Yeah.
That is the accurate statement. Stop the spinning. Stop the spinning. I mean, that's spinning for me and not truthful.
Yeah, see, I would like them to just hear them. I mean, they kind of alluded to it before, but I would just like them to admit that we don't have the manpower to approve all these visas in this year. Okay, I wouldn't like it, but at least honesty would be nice, because people, when I talk to people about this, they are frustrated because they're not hearing anything.
Because here they're high-fiving themselves.
Yeah.
They're saying we've done a great job this year, and we're going to repeat the great job that we did last year. We're going to repeat it this year again. When you think wasting 66,000 green cards is a great job, okay, what incentive do you have to do better?
Yeah, that's really
It's a mindset, and the mindset is wrong because you have failed by 66,000, and when you say that, Brian, when you say that, you begin to think, how can I do better? Because unless you say it that way, you cannot get better.
Oh yeah, and I think it's where are the consequences? The consequences are the people who don't get a green card. You know, it's not like everybody loses a bonus at USCIS or something like that. Maybe a director gets a tongue lashing from Congress, you know, a year down the road. But
our agency have failed to satisfy and implement
meet their legal obligations.
Congress's request and mandate of 66,000 green cards last year. We are on course to repeat the failure to meet Congress's mandate one more time this year. And therefore, we are going to start to think out of the box to see how we can meet Congress's mandate by perhaps cutting down the processing time of every green card in half and following the law. If the case appears approvable on its face, we approve it. We're going to cut down on 50% of the RFEs, 50% of the interviews, and approve these cases. And unless you change the mindset that we are failing, not we did 50% more and we're about to do 50% more this year and we're doing a great job, to we are failing and we must change how we do the process, you can never improve.
One wasted green card is a failure by the agency.
I mean, that's the problem I have. It's not the numbers. The numbers don't change. It's just the coming from, we did a great job patting themselves on the back that they've done 175,000 is where the problem I have. And we are going to repeat our success of last year again this year and do the same thing.
Anything less than issuing 281,430 employment-based green cards is not good enough.
When the message is honest with themselves, improvements could be expected. When the message is dishonest, improvements will not happen. That's the point I'm making.
So, gotta sort of point out some interesting things they said during this. They took a couple questions during this thing, and one of them really sort of stood out. So, somebody asked, if I filed a standalone adjustment of status, you know, basically based upon an approved I-140 with a current priority date in April of 2020, this year, they said, oh yeah, we think that's something that's likely to be approved this year, right? It boggles my mind then. How are they on track to waste 66,000 visas, but they're going to basically be getting cases approved in a matter of less than 6 months?
So everybody understand what was said.
Sure.
So to be clear, right?
Yeah.
So they said that if you have a adjustment filed on an approved I-140, right?
Yeah, a standalone adjustment ready to be approved. Yeah.
On April of 2022, they believe that they can get this case approved.
Yeah.
That's amazing if they do that. But if they do that, in my opinion, there are not going to be 60,000, 70,000 green card wasted.
Well, yeah. If they think they can, yeah, exactly. If they think they can get to a case filed in April, yeah, exactly.
And therefore, and again, it could be on the moment, spur of the moment response that's not well thought of. But that's the information that we have received, and we're relaying that to you. I wouldn't take it to the bank, but that's the best information available,
yeah.
right?
I mean, they also said, with a concurrently filed I-140 in premium processing, they said, they thought that could be approved this year as well. They sounded a little bit more skeptical, but it's.
But here's one thing that's unequivocal, I think, that comes out of this. If you have an option of filing a new adjustment or interfile a case that's been pending for prior to April, the transfer underlying basis is the better option of the two.
Yeah, I still, considering how little time is left in the fiscal year, I have to agree.
For right now. So if you haven't done your transfer underlying basis, do it. Now, if you have an EB2, an I-140 and EB2, and you have a new one, but you have a pre-April EB3 I-485, would you do a transfer underlying basis of that EB3 I-485
to EB2?
To EB2?
I gotta say yes.
Even though you have two adjustment status in EB2 running at the same time?
So
I would say yes.
Yeah, I mean, it's not a scenario I love. I can't help but think eventually you'll see a notice from USCIS saying we got to close one of these cases.
They won't do that.
Well, they'll approve one of them,
And then you can withdraw the other.
There you go. They'll close out one of them. When
I would be aggressive and do a transfer underlying basis on a EB3 to an EB2, which was if the adjustments filed prior to April. If the other one was post-April. Adjustment based on what I'm hearing here.
So their optimism they express here. So I'm going to go back to doing this. Here's 281,000. Here's 175, and they say, well, we're going to beat that. If they're getting to cases in April, I can't help but be hopeful that the amount they actually get done is closer to 281,000 than our hopes than what we think is going to happen.
In your opinion, Ryan, and I know you're going to tell me one case wasted is a failure. I know that.
Yeah.
So we're not going to get that answer. What number that you would say, what, they've done the bit, as impressive? What's that number?
Oh boy, that's a tough question. I can't.
I would say 220,000. I think if they can waste the same number again.
Yeah. There are more cases. More cases.
So if they wasted only 50,000, I mean, it's not a success, but I would say it looks like they tried hard, under the circumstance. But it's not a success by any means. It's a failure. Still, one case wasted, one case failed.
When I think of it, Sam, I think of how long these cases should be in process. I wouldn't be surprised, people filing new adjustments in 2022, I'd say maybe you're pushing your luck on expecting those to be approved. But man, anybody filed before the start of this year, I'd say you've given them enough time to approve the case. That's maybe the way I choose to think about it.
Yes. Thanks, Brian. This is really a good report. INA 245K is a wonderful legislation. Whoever wrote this law or thought of it, and I do not remember, I have to go back and see where it came, what administration that proposed this law. I don't remember, to be honest with you, but it is one of the very few super commonsensical laws in immigration law that we have. It's a wonderful, wonderful law, and it's worth that you understand its applicability very well, because it can save the day for you. First of all, it's related to adjustment status, right?
Yes. Not only that, employment-based adjustment status for people in the EB 1, 2, 3, and 4 categories.
Does not apply to EB5.
Yeah, they don't get the benefit of INA 245K.
Okay. And also, it applied to family members.
Yes.
So if a family member has had certain prior immigration violations, it could be forgiven. So not only is the principal, but the family members also can benefit in their own right which basically it says that if you have potentially violated your status for up to 180 days,
we'll excuse it and still allow you to adjust.
we may excuse it.
Yeah.
Okay.
So let's talk about why what the general rules for adjustment are,
Yes.
and then why that exception is important. So
Yes.
adjustment of status is discretionary, right? But there's a general requirement that if you have any employment or status violations in your time in the United States, they won't allow you to adjust. There's all sorts of exceptions to this rule, and for employment-based in the EB 1, 2, 3, 4 categories, it's INA 245K. And what INA 245K says, since your last entry to the United States, we will forgive failure to maintain your status, failure to unauthorized employment,
2,
and overstay.
overstay. So we will forget all those 3 on the account of total of 180 days.
Yes.
And we will be able to continue the adjustment of status and issue the green card.
Yes.
And that is wonderful. And the same thing for a child or a spouse who had gone through a status violation, unauthorized employment, or working outside the terms and conditions of their visa for up to 180 days or less, they can move forward and get their green card. Now, it sounds simple, but the devil is in the details, and there's a lot of nuances to this that we're going to dive right into it. First and foremost, Brian, and that's a waiver, by the way. INA 245K is a waiver, okay? But there's no form to complete, no filing fee to do, and there's nothing you need to do to take advantage of INA 245K. You complete your adjustment application, you answer all the questions truthfully, you provide all the evidence necessary, and you submit your application. You don't do anything else special, which is wonderful. Then if the reviewer notices that there are status issues in the application, they could come back to you and say, explain this to us, and maybe you can claim INA 245K if applicable. Yeah. So it's easy, it's so easy to do. There is no window of time that if you didn't claim it, it passes. There is no fees involved. There is no complexities in the law. It is done on such a commonsensical way, which is really refreshing. Yeah. Which is fantastic. Now, counting the 180 days.
Yes. So
how it counts is critical.
So we talked about 3 things that INA 245K would forgive: status violations, not complying with the terms of your status, not working while you're on H1b, not going to classes as a student, that sort of thing. Overstays, going beyond what your I-94 says you're allowed to stay for, and employment authorization issues, working when you're not supposed to be. So the interesting calculation thing is, say if 2 of those things happen on the same day, your I-94 is expired and you work for a day without authorization.
So you have 2 violations in one day.
Yeah.
How many days does that count?
They will count it against you as one day.
As one day, which is a wonderful way to do it.
Yes.
Right? It's fantastic, because they could have easily said, these are 2 violations in one day, it should count as 2 days. No, it counts as one day. So it's extremely forgiving in the way it calculates. So they combine 1 or more violations per day as one day. Now, weekends and holidays.
So basically, these things are kind of relevant in employment authorization issues. So if you're not in status, you're not
Most
in status.
relevant in employment authorization.
You're not in status, but the interesting question comes up with employment. Say, you work unauthorized on a Friday and you work unauthorized on the Monday afterwards. Do they count the 2 days in the middle, the weekend?
And they do.
Yeah, they do.
And they do, because the example that Brian brought up is the unfair example. But what happened is, if let's say you worked from January 1st to March 12th unauthorized, okay, they're not going to go and subtract weekends.
Yeah.
And if there's a holiday in the middle, they're not going to go and subtract. They're going to count the calendar days from January 1st to April 12th, and they're going to say you have 25, 45, 47 INA 245K violations, type violations, and then they will put that in the Excel sheet to add the days and hopefully reach less than 180 days. So that's the really important issue, is how numbers are calculated. Now, with regards to family members, it's the same way, Brian, right?
Yes, correct.
Okay. What other issues you want to dive into? With
Well, I think it's worth noting that probably INA 245K or violations of your employment authorization, your non-immigrant status, and your terms and conditions are surprisingly easy to accrue. And it's my general opinion that most people we have something out there, and they probably don't know about it.
And you shouldn't panic about it because you have very little of it.
Yeah.
And the beauty about INA 245K is if you've left the U.S., you have left the U.S., let's say you went back home on a vacation, and then you re-enter the U.S. Any violations that occurred prior to your departure get wiped out.
Yes. However,
with one exception, which we'll talk about. So when you re-enter again, you reset the clock on any violation.
USCIS, if you read their policy handbook, it's very clear. It's, if you have violations during one stay, you leave the country, in good faith you get a new visa, come back to the country, and those prior violations, even if they exceed 180 days, don't matter to them. You're on a new stay, great.
There's two catches. If you have to go for stamping, if you have to go for stamping, and you're aware of those violations, you must divulge these violations to the consulate when you obtain your visa, because INA 245K does not
excuse fraud or misrepresentation.
Fraud or misrepresentation.
If you come back to the United States by lying, essentially being untruthful, well, INA 245K will wipe clean the violations from the prior stay, but it won't wipe clean fraud or misrepresentation, which is its own immigration violation, which can get you in serious trouble and cause the denial of a green card.
Exactly, and that's not forgivable under any circumstances. I mean, there is a waiver for it, but
beyond the scope,
beyond the scope, and also you may not be eligible to it for it. These are difficult waivers to obtain under very narrow circumstances. Now, the second one is very important to understand, and if you haven't paid attention, you should listen to this one.
Yes. So, advanced parole, entering on an advanced parole does not wipe the slate clean. That's what you're getting at, correct?
Yes. So, if you enter the U.S. on an advanced parole, that's not considered an admission, and therefore, it doesn't reset the INA 245K clock fresh. Practically. So let's assume you've had 181 days let's assume you have 175 days of immigration violations before you left the U.S. Then you come back to the U.S. with a new visa or on your old visa and you enter the U.S. a second time, the 175 days are gone. And then let's assume you do another 10 days of unauthorized employment. Now you file your adjustment of status, you only count 10 days, and it's less than 180 days. It's wonderful. Now, left the country, entered on the visa. All the 170-day violation or 75 days of violation long time ago before you left the U.S. are wiped out. Now, same scenario, but you didn't enter on a visa. You entered on an advanced parole. It doesn't reset the old 170 days. Then you enter the U.S. and you commit, let's say, 11 more days of violation. 170 plus 11 is what?
186?
181.
Oh, you said 170. Okay, yeah.
I'm changing numbers. That's beyond 180 days. You will not be able to adjust. So because you used your advanced parole to re-enter the U.S., violation occurred during the prior stay gets added to any violations that may have occurred after your re-entry on advanced parole, and they get added up, and if it's beyond 180 days, it's a problem. And that's one of the things people don't understand about advanced parole. It's different than getting on a visa because it doesn't wipe out prior violation. If you have prior violations, don't use advanced parole, use your visa, and especially if you have a stamping.
Yeah, so it reminds me of something funny. Sometimes I go into a green card interview with somebody, and they'll be sitting with me before the interview, and they'll say, Brian, I'm a shoo-in. I haven't left the United States for 10 years. 10 years, not a problem.
And you say, oh my God,
I say this for after the interview, and I shake my head. I'm not trying to worry anybody before going to the interview, but I said, when I have a cup of coffee with the mattress, I say, hey, by staying in the country, you're giving them a decade's worth of time to search for those little immigration violations.
Yes.
And it's worth noting, Sam, So, I mean, we talked about there's so many common sources of these. I mean, students can easily, let's see.
Drop below 12 credit hours.
And when you're on OPT or CPT, not, going over your allowed days of unemployment. USCIS misses those a lot of the times when you change to H1B, but when it's time to give away a green card, they might turn on their magnifying glass and really look at you,
Yeah, absolutely, and these can add up.
Yeah.
Now, on a reinstatement, so one of the things that there's a couple of things about the INA 245K reinstatement.
Yeah.
Do you want to tackle that one, Brian?
Yeah. So in the context of of a student status,
Yes.
There's something called reinstatement, where you essentially file with USCIS to say, "Ooh, I messed up my student status, but I'd like to fix it," and they actually fix all that status violation time with a reinstatement. So that's a nice positive policy. Again, part of the whole fact that INA 245K is really nice for people. It does really fix a whole lot of issues.
And that is wiped out. It doesn't count against the 180 days. So that's wonderful. So let's assume you work without authorization because you thought you were authorized under certain circumstances, but maybe EAD expired or the CPT on the I-20 dates were confused, or you dropped below 12 credit hours, and then you go to USCIS and say, through your school, and say, please forgive me, please reinstate me, it's beyond my control, here's what happened, here's the situation, and they reinstate you. It doesn't count as part of the 180 days, which is wonderful.
Yeah.
All right, so we can talk about technical violations. What do you think?
Yeah, what do you got?
Yeah, so technical violations are those violations that are beyond your control. And these are days of violations, potentially, that are forgiven and they don't count part of the 180 days. Example, you get an email from your employer with an LCA. This says, I have amended your H-1B. Here's your new LCA. Go ahead and fly to Dallas or Hawaii or, and for my client. And you get your LCA and you fly. And then you discover later on that this amendment was not approved or this amendment was never filed. That evidence, that email that you have that you thought that you were permitted to work in that location, but in fact you weren't, and you can show that, that's a technical violation. That's beyond your control.
Yeah.
And
I guess for me, the big point of this is there's three categories, and we can talk about them very simple things that INA 245K says, but there's really opportunities for good lawyering in there if you're in a really serious situation, making the argument that these days don't apply for it's beyond so and so's control.
Benching, for example.
Yeah.
Your LCA salary is $100,000. You ended up getting $100,000 at the end of the year, but there's 2 months you weren't paid. There's argument we can say is beyond your control. Obviously, it's within 180 days. We don't have to argue. What we can say is less than 180 days. Don't waste my time. Approve the green card. But let's assume that when you add them up, now you cross the 180 days. We start looking into are they technical violations? What you got paid with the LCA is just the employer didn't pay you for 2 months, which is an employer violation, but you really complied, and it's not like you can go to the bank and pull the money from the bank yourself. If he doesn't issue the check, what is it? I mean, it's not your fault, so this could be argued as technical violation.
Yeah, fun. Like I said, fun,
Yes.
Challenging attorney
Yes.
work for sure.
Now, when the attorney dropped the ball and doesn't do anything, is that a technical violation per USCIS, Brian?
Generally speaking, courts don't think it is.
Yeah. So unfortunately, attorney dropping the ball, it looks like USCIS's opinion is not a technical violation, and it will not excuse you from counting towards the 180 days. So that's the INA 245K. Is there anything else that we have to talk about, Brian?
No, I think that we really over the head. It's something to for me, if I want to sum it all up, for a lot of people, it won't come up, right? But it's something to have in sort of the back of your head. If you're worried about your green card case, it's if they find a little problem somewhere, it's you have 180 days of playtime, to basically take care of you.
It doesn't come up because it's so generous.
Yeah.
But truthfully, in every case, there is a day, 2, 4, or 15 days, a change of employment.
Yeah.
you get a receipt notice, but the employer tells you start 2 days before, puts pressure on you. Or there is on the H1B amendment, you moved to a new location a week before the amendment is filed. All those add up.
I want to make some good attorney arguments there about whether it was a true work site. Fun, but yeah, point
Well, give
is,
me one.
Oh, well, I mean, the H-1B rules are ripe with opportunities where you can go somewhere else for a little bit and they won't be considered a work site, and thereby that might not be considered a violation.
Fantastic
I guess,
answer.
We've heard of scenarios where, there's
if
they have tons of violations, every one of them is a spot where you can argue it down. As always, you can, as an attorney, is you can get somebody's days below 180.
Yes.
You're a hero because you saved their green card.
Yes, absolutely, and it's worth it to argue those things.
Yeah.
So INA 245K is a wonderful law that can save your family's green card. For me, the thing you should remember, it doesn't apply to EB-5. It applies to family members. There's a technical violation provision that can forgive you for things beyond your control, and it applies. I did say apply to family members, and the counting is, I think, generous, and that's it.
Yeah.
All right. Well, thank you guys, and back to Sam.
I like that guy. I hope he does well.
Well, I hope this presentation was insightful and helpful today. And for those that missed the first 30 seconds of the presentation, my dear colleague Brian Burke is on vacation. We allow people to go on vacation every now and then. And right before he left, we recorded that session. He took off, I think today is his first day on vacation, and he'll be back in a few days. And so we wanted to give you the dynamics of two attorneys discussing it. It's not as much fun as one person talking about it for half an hour. So we did that. Hopefully it is successful. And I will be answering your questions today. And let's take the first one. All right, so let's see here. All right, so first question from Mandeep. And then the word also tells me that there was a prior communication on the topic and may have preceded us going on live. So the information entered before we go live sometimes are cut off, and I apologize for that. So we tried to catch them. If we didn't, please bring them in and we'll take care of them. But for Manjeeb, he said, is USCIS yet to apply the horizontal spillover? Is it expected to be done in quarter number 4? It is typically the spillover from EB. So for those who don't understand what a horizontal spillover means, is when a spillover from all chargeability, all countries, to the backlog countries being China and India, typically that occurs at the 4th quarter, and we hope to see that at the 4th quarter. That's correct. All right, taking the next question from Rajini Gupta. Can L1b apply for EB1C, which is the EB1 intra-company transferees, which typically not reserved, but it is kind of a perfect fit to the L1A. So the question is, can an L1b apply for an EB1C if all the criteria are met? Alternatively, is there a way to convert an L1b to an L1A? Let me answer the second part of the question first, which will make answering the first part of the question easier. An L1b could be converted to an L1A through more than one path. The obvious one is a promotion within the company to a managerial level, and then you file an L1A petition, and once that's approved, the L1A takes over the L1B, and you're on L1A. So the first question, can an L1B apply for an EB1C? Yes, but you got to upgrade yourself to an L1A first, because the EB1C is multinational managers or executives. Now, while the criteria are met, but there seems to be a conflict between working in the United States on an L1b and being a manager. Because L1b is specialized knowledge, and L1a is a managerial, and it's very difficult to convince USCIS that you really were doing and dangerous, that you were really doing managerial work, not specialized knowledge, or you were really doing both, and now you want to take advantage of the L1a component of your activities here. It doesn't really fit very well, and I wouldn't do it. I would upgrade or get a promotion and get an L1a and then move on to, and not immediately, after a short period of time, to filing an EB1C or a multinational manager or executive petition. All right, so going here to Neela, and I'm not going to try to mispronounce your name. I apologize for not pronouncing it correctly. But the question is, are you seeing I-485 getting transferred from TCS with pending EB3 I-140? I downgraded in October 2020 and waiting for an I-140 approval. My EB2 I-140 is approved and current in June and filed interfile. No, we are not seeing cases transferred when the underlying I-140 is pending. If you interfile to EB2, you may get transferred once USCIS grants that approval. Hopefully that answers your question, but no, we're not seeing a transfer if the I-140 is not approved. All right, so moving here to Mandeep Raj. USCIS yet to apply the horizontal spillover. I think we did that one. Let's move on to let's see here, maybe we've skipped one or two. So this is Regina, if the spillover sequence from family-based to EB is EB1 to EB2 to EB3, then what caused the EB3 movement in 2020? How did the spillover skip EB2? It's a fantastic question. As a matter of fact, I love that question because somebody is thinking seriously and deeply about it. So back in October 2020, what happened is they did not move the final action date. They moved the date for filing. The final action date is moved through a controlled regulatory process, meaning that they have to look at how many visas are available per certain calculations or methodology, and how many cases in the pipeline, and move the priority date for filing based on that formula. Whereas the date for filing is a look forward date, and it is subjective. And typically the State Department like to keep they say 8 months to a 1 year forward look, meaning that they would like you to get those cases filed a year before the final action date would be current for that specific case. So what they've done is they moved the EB3 date for filing because they couldn't move. As a matter of fact, they didn't even move EB1 to current, what they should have done right away. So I think back in October 2020, there was an absolute and substantial miscalculation of what they should have done. Clearly evidenced by the fact of asking us to interfile right now and moving EB2 forward. I mean, clearly, total and absolute miscalculation of what they should have done. So they've done the date for filing, and that's why they can do any of those. They can move any of those dates. I have no idea what possessed them to move EB3 and ignore EB2 and EB1. EB1 remained not current. Then they kind of figured things out. It took them 6-7 months to figure out what's going on. So hopefully that answers your question. All right. So moving on to Dr. J. Goraya. After filing I-131 concurrently with I-485, if someone travels outside the U.S. before the approval of the I-131 and return back to the U.S. on H-1, H-4 visa, does USCIS reject the I-131? And if yes, can they refile? The answer to that question is absolutely. USCIS will, Dr. Goraya, will reject the I-131 because it's considered abandoned. Now, you can refile it, absolutely, not a problem, if you wish when you return to the U.S. And our friend Dr. Goraya, or Joraya, has a continuation. If someone does not refile I-131 and just maintain their non-immigrant visa instead, would it negatively affect or impact their I-485? And the answer to the question is no, it will not have any impact on your I-485 whatsoever. So there's really nothing to worry about when it comes to a rejected advance parole and then you decided to not refile it. However, it doesn't make sense not to refile it because there's no filing fee involved. So might as well get it refiled and get that advance parole. It's an excellent document to have as a backup due to embassy backup, emergency travel, other complications with your non-immigrant visa. I wouldn't ignore it and not file it. All right, moving on to next question. Do you think filed in June get approved this fiscal year? So USCIS, per the new ombudsman presentation or webinar that they put together, they believe cases filed April or before of this year will be approved. So if you file the case in June, that seems to be, it's beyond April. So it's a push that we anticipate approval based on the information they provided us last week. All right, next question from Sweet Seller. Our friend Sweet Seller loves our show and we love him. For green card holder, what are the documents required to travel to India and travel back to the U.S.? Does a green card holder need a visa to travel to Mexico? Well, first of all, the document you need to travel to India or any other country and travel back to the U.S. is an international passport. And that could be for a permanent resident. You can have, for example, if you are an Indian citizen, you can have your passport, your Indian passport. There is a U.S. travel document that you can obtain, and then your green card, your permanent residency card. Those are the two documents you need, a passport and a green card. Now, with regard to does a green card holder need a visa to travel to Mexico, the answer is no, they do not need a visa to travel, and that's per the information on the U.S. consulates in Mexico. You do not need a visa to travel to Mexico for U.S. green card holders. All right, so going on to Sagar, refiled in EB2 at NBC, non-concurrent, also had pending I-140 EB3 at SRC, which got an RFE. Will USCIS wait for EB3 I-140 RFE to be responded to in order for them to adjudicate EB2 I-485, final action date current in EB2? The answer is no. They live in a completely different sphere. The EB3 case and the EB2 case will not slow one another in any way. So they will not wait for any decision on one to take action on the other. Rahul Jain. Hello, Sam. Hello, Rahul. How are you? Do you think unused EB3 visa numbers, approximately 55,000 that Charlie talked about last year, can get EB3 to move forward? We expect movement in the EB3 in October, but not before that. I think at this point, I think there is sufficient EB3s to go applications to cover a mountain. They want some of that stuff shifted to the EB2s, as a matter of fact, because they just simply do not have enough EB3 allocation to approve all the EB3 cases, which we knew that months and months ago, and then the government now has figured that out. So I don't think there's going to be a forward movement, in my opinion, and I don't have a crystal ball, but in my humble opinion, I don't think there is going to be a movement before October. All right, so from Meena Ram, my priority date is September 2013. Downgraded in October 2020 to EB3, received advanced parole and EAD, will be filing interfile 485 Supplement J this week. Do you hope that I would get green card by end of fiscal year, September 2022? I think so. We are seeing interfile cases moving now, and looks like USCIS is ramping up approval. And based on everything we are seeing and what they told us last week, your case should be one of those that should be approved this fiscal year, hoping that they don't waste too many cases. But we hope, very optimistic, that we can certainly see that your case probably will be approved. All right. From Sweet Seller, just want to pass on info about SSN. Thank you, Sweet Seller. Getting delivered after green card. Not everybody seems to get it automatically. May need to file an application going to the Social Security Administration a week or two after getting green card. I would like to get Sweet Seller's experience at the Social Security Administration. What has he experienced? How long of a wait was it? Drop that in, Sweet Seller. If we have time, we can definitely pass it on. And if we don't get it this time, please be patient and share it next week. Going in to talk to Mr. Raul Jain. Also, do you think any forward movement in EB2 in July bulletin, final action date moving from September 2014 to December 2014? That's an excellent question. So on my prediction sheet here, I am of the opinion that EB2 India, depending on the number of interfiling coming in from EB3, so that's kind of a conditional prediction, I see movement to January 2015 in the next 2 to 3 months. How much they're going to do it and how fast, depending on the how many interfiling they're getting right now. Because here's what we know: there's approximately plus or minus 280,000 green cards that they need to allocate this year, and there is in their warehouses about 280,000 cases. So they have exactly the number of cases, assuming no waste, to adjudicate to a 100% based on the available green cards this year. And the only thing that is inhibiting them from being able to do that is the fact that there's a lot of them are in the EB3 category. And by the way, this push to move interfiling hasn't yielded a lot of interfiling cases, about maybe 15,000 or so, but not massive numbers. So they want more people to interfile. So if the interfiling from EB3 to EB2 is slow, I see a push to move that final action date back to the EB3 dates for filing that they did back in October, which is January 2015. So what that does, it opens up the gate wide open to any case that was filed in EB3 to jump on the EB2. So, but if we see a lot of interfiling cases that happened in the last couple months, and we're seeing some activities in our office in that regard, then I would say that that movement will be slower. So we'll see, I guess, soon what's going to happen in next months. All right. So now looking at Sriva. Have you seen any approval for EB2 refile in January or later this year for the downgraded petitions to EB2 cases in October 2020? Yes, as a matter of fact, we start finally seeing these cases getting filed, approved. Not a lot of them, but we're seeing them. Yes, positively we are seeing improvement in that area. All right. Coming here to KJK. With this, do you expect the final action date move to go forward? I think we just addressed the final action date movement, but I don't think the final action date movement is related to the number of approval. I think we're going to see the final action date movement in EB2 related to the number of interfiling, in my opinion. All right, and to talk to Jolly Male 121. All right, switching from H1B to F1 for PhD allowed. You're switching from H1B to F1 at any time that is involve a legitimate course of study is 100% allowed, yes. Will it cause any issue with pending I-140? Ah, you got an I-140, you didn't tell me that. If you have an immigrant petition, which is an I-140 for you, it is not likely that you will get an F1 approved, F1 visa approval, because an F1 visa has a non-immigrant intent in it. And having a non-immigrant intent conflicts with an F1 visa status. And therefore, I don't anticipate that your F1 visa will be approved if you have an approved I-140 or pending I-140. And therefore, switching back from F1 to H1B probably irrelevant. But if you have, assuming you were successful in switching to an F1, you will be able to reuse any unused H1B. And if you have an I-140 approved, obviously you can go beyond 6 years as well. So hope that addresses your question. All right. Vijay Singh, spouse and I have been pending I-45, pending EAD, and advanced parole. Applied for an extension, applied for expedited advanced parole for both of us. If approved, can we re-enter back into the U.S. on the basis of only the AP and be able to work? Well, if you have a pending EAD, not approved EAD, when you enter back on advanced parole, you really do not have a work authorization. However, if you were on H-1B status and you rejoin your H-1B employer, even you don't have a valid EAD, there is a very old memo that permitted that, rejoining the H-1B employer after returning on AP without having an EAD. But if you do not have an H-1B and you re-enter on advanced parole and you do not have an EAD, then you're not permitted to work in the U.S. It is 7:01. I will take one more question and we will go from there. All right, so last question here from, well, hi Brian, this is Sam. I'm sorry Brian is not here, but I will make sure I deliver the message. I got my green card 3 weeks back. Whoa, Sayyid Ahmed. All right, congratulations. EB2 straight with November 2012 priority date. I think USCIS can issue all visas this year, at least for EB2. Well, thank you, Sayyid. Let me see here. He has a follow-up. Let's throw that in there. They approved my case in just 1 month. That's fantastic, Sayyid. This is wonderful. Congratulations. I'm very happy for you. and then applied in March, approved in May. Don't tease, everybody's been waiting forever. All right, I'm taking the last question here. But I thought they are really confident of using all visas. Actually, I felt more confident with the Ombudsman's meet and the other USCIS meet where Doug mentioned they want to use all visa. Well, I hope you're right. I hope we're wrong. But our read of it, they said they are on par to exceed last year's numbers. And last year they only approved 170,000. So to approve from 170,000 to 280,000, if I do the math, that's 110,000 or whatever, or 90,000, whatever the number is. And that's a large number. So to me, is to approve 110,000 beyond 170 is a massive undertaking, and that's not the feeling I got. I got the feeling that they are going to be approving more than 170. They're very proud of that, but they did not see any promise that they're going to approve all of them. I hope I'm wrong. I hope you're right, and you guys have a wonderful day.